a member of the community. I think he was in his vehicle, and he proceeded not only to hold him up, but he fired, wounding him, and then proceeded to pick up the spent shells that had been ejected after firing and wounding the complainant. In Morrison, the appellant appealed the dismissal of his appeal by the Court of Appeal of Jamaica to the Privy Council against the imposition of the minimum sentence of 15 years for wounding with intent with the use of a firearm, count on the basis that the sentence was prohibited by the Charter of Fundamental Rights and Freedoms, Constitutional Amendment Act 2011, and therefore unlawful. The board held at paragraph 55 that it was, and I quote, satisfied that the minimum sentence imposed in this case was not incompatible with the Charter, but accepts that considering the wide operation of the provision to children, there may be cases where the minimum sentence would constitute inhuman or degrading punishment or treatment. That does not, however, require the board to strike down that portion of Section 20 of the OAPA containing the minimum sentence provision. In dismissing the appeal, the board decided that there was no evidence that the minimum sentence provision in Section 20 of the OAPA did not satisfy the test stated in Christian Institute and Lord Advocate. And at paragraph 88, it was stated, this court has explained that an ab ante challenge to the validity of legislation on the basis of a lack of proportionality faces a high hurdle. If a legislative provision is capable of being operated in a manner which is compatible with convention rights, in that it will not give rise to an unjustified interference with Article 8 rights, in all or almost all cases, the legislation itself will not be incompatible with convention rights. The proposed amendments must therefore be assessed in accordance with the test, and this is our submission, applied in Tafari Morrison. The board outlined how the question of constitutionality should be assessed in detail at paragraphs 50 and 51, where it said, and we quote, the legal approach to the determination of the constitutionality of a minimum sentence is quite different. The court must determine, and may I just indicate again, that we understand the emotional underpinning of the concept of a child and the issue of mandatory minimum sentencing. But we pause to outline from Tafari Morrison that in the final analysis, it is really a legal consideration, taking and embracing the issue of whether the sentence could constitute inhuman or degrading punishment or treatment. The court must determine whether the imposition of the minimum sentence constitutes inhuman or degrading punishment or treatment. Such treatment is contrary to the Universal Declaration on Human Rights, United Nations Convention on Torture, the ICCPR, the ACHR, and Article 3 of the ECHR. The protection against such treatment is typically a feature of every Caribbean constitution, and clearly that would include Jamaica. My words. The test for such a finding is stringent. The issue is whether the imposition of the sentence is grossly disproportionate. The cases provide an indication of the stringency of the test. In Reyes and the Queen, 2002 UK PC 11, the issue was whether the mandatory death penalty for murder was inhuman or degrading and therefore prohibited by the Constitution. The board considered that to deny the offender the opportunity to persuade the court that the sentence of death was disproportionate was to treat him as no human should be treated and to deny his basic humanity. We are now at paragraph 40 of our submissions. However, it should be noted that an examination of several jurisdictions across the world would suggest that mandatory minimum sentences for child offenders are not common or even encouraged. So we would concede that when you look at other jurisdictions, it would not be common and it is not even encouraged. A step in this direction would require a statistical approach to justify that indeed longer periods of detention are needed to effect proper rehabilitation of youth offenders. And perhaps I should say that this is our concession to the emotional underpinning raised by other stakeholders. Because in the final analysis, for youth offenders, rehabilitation would have to be at the core of the treatment of youth offenders when it comes to sentencing. The issue of mandatory minimum for a child, we submit, should only arise in capital murder cases. That is, murder falling within section 2, subsection 1 of the OAPA. Have it. And just for clarity, that would be, give me the listing. Murder in the course or furtherance of rape, murder of a judicial officer, a contract murder, murder of a police officer or any other law officer in the course of his duties, murder in the course or furtherance of burglary or housebreaking, murder in the course or furtherance of arson in relation to a dwelling house, murder in the course or furtherance of robbery, murder in the course or furtherance of any sexual offense, and of course, murder of multiple persons, as was done in the Coca-Peace case. So those are the categories under the section 2(1) of the Offence Against the Person Act. And we are saying that it is in relation to those cases only, that the issue of a mandatory minimum sentencing regime should occur, where the period of not less than 20 years is specified. Because you may recall that for wounding with intent, as happened in Tafari, Morrison, the mandatory minimum there was 15 years. The proposal Parliament, or I'm sorry, the proposal of the policymakers would be 20 years, mandatory minimum. And we are saying from the Office of the DPP that that mandatory minimum should only be effected in capital murder cases where children are in conflict of the law. We also submit. So in other words, the child would have to serve a minimum of 20 years before being eligible for parole, notwithstanding Section 3 of the Offence Against the Person Act. It is further our submission that Section 3B of the Act should then read, in the case of any other offence or murder not falling within Section 2, subsection 1 of the Offence Against the Person Act, specify a period which that child should serve before becoming eligible for parole. So what we would be recommending is that in all other murders, the discretion, the judicial discretion should still obtain. So it would be open to the court in all other murders, separate from capital murder cases, for the court to use its discretion. And we have 2 or 3 cases that we have found. Yes. There are 2 or 3 cases that we can recall. This is one. Where children in conflict of the law have been sentenced, I think, to up between 13 and 18 years. And these were children who committed murder. We would also recommend that as part of the future legislative reform, that consideration be given, perhaps I shouldn't say creating, but enhancing. And I hope Dr. Sophia Longmore is hearing me say that. In enhancing an appropriate rehabilitation program for youth offenders who are serving a mandatory minimum sentence for capital murder. We take this approach as capital murder as a matter of policy and as a matter of the public interest, the policymakers recognizing from very early how egregious and how traumatizing these offenses can be to the community, have made sure that these cases are on a different sentencing track for adults. We submit that the policy should also encompass children in conflict with the law. Further, there may be persons, we believe, who may seek to use a child to commit any of these categories of capital murder. And it cannot be that in the same way that it used to happen, it still happens. We have seen it in our files. We have prosecuted cases like that, where adults will give guns to children to hold and to carry and to commit an offense with the hope that they, the adult, will escape the full extent of the law. So in terms of the policy, it must be out there, we believe, that or in the public domain, that if an adult hoping to escape the full extent of the law in terms of capital murder engages a child to do what was done in the Coca Peace case, that is to kill 5 people, or to effect a contract murder, or, God forbid, to kill a police officer, or to kill a judicial officer. It must be out there in the public domain. There must be some assuaging of the public angst that the policymakers recognize that even if you are a child, if you come in conflict of the law in terms of committing capital murder, you will be incarcerated or without your liberty for at least 20 years as a matter of law.
Could I just ask your opinion on that very point, DPP?
Yes.
Suppose an adult gives a child to commit a capital murder.
Yes.
We know that the child cannot be sentenced to death.
But can be sentenced, well, yes.
Lesser or even lesser penalty. Is it your position that the adult could be sentenced to a higher penalty, consistent with the capital?
But we would indict the adult as being an accessory before the fact to murder, or depending on the circumstances, if it's quite clear that the adult is participis criminis in a common design to kill, then we can indict for murder. However, the case law have made it clear. You may ask, why couldn't we then indict the, well, could we indict the adult for capital murder? Strictly speaking, we could, but that adult would not be subject to the full extent of the law in terms of sentence to death in the manner prescribed by law, or perhaps even the full extent of parole, perhaps not before 40 or 50 years, because the adult would not have been the trigger man. The case law has made it quite clear that for anybody, an adult, to be liable to the full extent of the law as it relates to capital murder, the offender has to be the trigger man.
The way you presented it suggests that the child may well
be the trigger
totally
man.
Innocent.
The child will be the trigger man.
In many ways being coerced or encouraged to be the trigger man.
but I say it with the greatest of respect. As a prosecutor, we cannot speculate. We go with evidence. So in the absence of evidence as it relates to coercion, we would be obliged to indict. And even so, the law is quite clear. I think the case is Abbott and the Queen, where the concept of duress as it relates to murder is unknown. That is the case, I think, is it from the Privy Council, that duress is not a defense in law to the offense of murder. Because had that been so, as a matter of common sense, then everybody would come and say that they were coerced.
I'm not concerned or concerned that the child offender may well get a lesser sentence, the actual trigger person who is the child. What I think the public at large would be very concerned about is whether, let us say, they're gang members or an adult who use the child to be the trigger person, whether they shouldn't get the full, punishment of the law.
Well, you mean the adult?
The adult.
Well, I think perhaps, may I have a moment? Okay. Perhaps Parliament dealing with child offenders, you could amend either the Child Care Protection Act or the Offence Against a Person Act to make it a special offence if it is that there is evidence that any child who commits murder or capital murder, if there is evidence that they were coerced by an offender, then you would attach a particular type of sentence to that adult who is found guilty of coercing that child. So that is something that the policymakers could think of, because one really wouldn't want to see a loophole opened where children are, or let me put it this way, there is an enhancement of children being used to perpetrate heinous offenses.
Well, it's a matter for the policymakers, obviously for this committee to make that recommendation, but it is a concern even from the presentation from UNICEF. That was one of their arguments, that the children are really succumbing to the encouragement, put it no stronger than that, of persons who, encourage them to commit the offense.
And with the greatest of respect to that view, in our files, we have seen several occasions when sometimes it's a child that is running things. Yes. man, I nearly said my lord. Chairman, I go to court as busy as I am for a reason, so that I can see what is happening. And I will never forget being in the gun court as DPP. And there was a child, handsome fellow, no more than 15, before the court for illegal possession of firearm and wounding. And you know what was his pet name in the file, in the statement of the complainant? Lord Evil. To say I was flabbergasted is putting it mildly. and the investigating officer was able to tell me of the progression of that child in respect of offences, and now he's before the court for illegal possession of firearm and wounding with intent. So I say with the greatest of respect, there is a reason why we on this side are guided only by the evidence based on what we have seen. It's dangerous to speculate because you may get a shock attack. So we would reserve on that issue of coercion only where you have the evidence. You cannot make assumptions. Okay. Just to go on further, and I think I'm finishing up now. We submit that having regard to the latest authority, Tafari Morrison, from the Privy Council, that the proposed amendments, as we have sought to tweak, would satisfy the test of constitutionality outlined above. The legislative framework and objectives that apply to the offense of wounding with intent, as occurred in Tafari Morrison, would a fortiori apply to the proposed mandatory minimum. But we say in relation to child offenders in capital murder cases. However, to ensure that children are not subject to the concerns raised, I think, on the last occasion, we recommend that a review of Section 42K of the Criminal Justice Administration Amendment Act 2015 could be done. Section 42K states that where a defendant has been tried and convicted of an offense that is punishable by a prescribed minimum penalty, and the court determines that having regard to the circumstances of the particular case, it would be manifestly excessive and unjust to sentence the defendant to the prescribed minimum penalty for which the offense is punishable, the court shall sentence the defendant to the prescribed minimum penalty, and B, I think that should be shall, issue to the defendant a certificate so as to allow the defendant to seek leave to appeal to a judge of the Court of Appeal against his sentence. So we believe, Chairman, that the concerns raised by the honorable members of the House, and I believe UNICEF, could be met by retaining or amending 42K to fit the issue of children who, if there is a mandatory minimum for capital murder, but when one looks at the social inquiry report, when one looks at maybe a report from the Children's Advocate Agency or the other agency that deals with children, or with the psychiatrist's report, there is an element of coercion, or the probation report, or any report, there seems to be some element of coercion creeping in. The law, in terms of our indicting and trial, cannot in any way give credence to duress. But in terms of sentencing, though there's a mandatory minimum, even if it is that the child has been found guilty of the murder of a judicial officer or police officer, or 4 people, there would be room, if the judge is persuaded by arguments of counsel or by the psychiatrist's report, for the judge to issue a certificate to the Court of Appeal for the Court of Appeal in their review, looking at what the judge is saying in respect of the reasons, because the judge has to give a reason why they're issuing the certificate and why there should be a sentence below the 20 years, say 19 or 18 or 17, then it would be for the Court of Appeal to review, take that on board if they deem it appropriate, and then they would be able to go below the 20 years. So we thought that that was a judicious and equitable way of balancing the needs of the child vis-a-vis the need of the public interest and the community to know that if there is this heinous offense committed by a child, then the law will take its course in terms of mandatory minimum. But in terms of the justice balancing exercise, there is room for the certificate to be issued if it is appropriate and for the Court of Appeal to review to go below the mandatory minimum. And also, so this is for those who are cynical, who may view the whole issue of a mandatory minimum as prescribing inhumane treatment. But as we say, Tafari Morrison has upheld, in effect, the constitutionality of a mandatory minimum sentence for a child. So the proposed amendment of Section 42K would seek to ensure and assuage any concerns that if there is a necessity, even for capital murder, for a departure because of the special circumstances of that child from the mandatory minimum sentence, the amendment to 42K and the issuing of that certificate would see that justice or consideration is duly given to the fact of the offender being a child, though the offense committed was very heinous. Now, Section 20 of the Plea Negotiation and Agreement Act states that the prosecution may enter into negotiations with a person convicted of a crime and serving a sentence. It is our recommendation that the proposed amendments expressly state that they do not repeal, replace, or limit the scope and ambit of Section 20 of the Plea Negotiation and Agreements Act. And for the non-lawyers here, the Section 20 of the Plea Negotiation and Agreements Act is a very important section. In fact, the whole scheme of the Plea Negotiation Act, which we have been using at the office fairly frequently now, it allows the prosecution to make recommendations of sentencing and for the judge to accede to those recommendations where the sentence would be below the mandatory minimum. And we have done that. The very famous, though he was not a child, the famous case of the Queen against Tesha Miller is one big illustration of the use of Section 20, where we went into plea negotiations after the witness who was serving a term for murder and arson had already been sentenced. And he got a significant number of years shaved off his original sentence. So we would want to make sure that there is clarity by the policymakers that Section 20, if it is, that there's going to be a mandatory minimum sentencing regime. Because the child could give evidence. The child could take advantage of this or even enter into a plea negotiation through his lawyer and be prepared to give evidence against the adult who he may be saying coerced him or engaged him or made a promise of some reward for him to get. So we would then be able to use that child's evidence against potential adult offenders.
DPP, while you're on that, I don't think, unlike the Firearms Act, that the proposed legislation has excluded the Plea Negotiations Act. And I hope your position would be that it should not.
This is what we're saying.
No, right, but
it
I'm
should
saying not only Section 20, but
the entire act.
Should.
Yes.
And the reason why I would also suggest that too is that if we retain the Plea Negotiations and Agreement Act, then your proposal in 42K may not be necessary, because when if the person is encouraged or pleads guilty, then an appropriate sentence can be suggested by the DPP and the defense in order to attract a guilty plea or to encourage a guilty plea, which means that the mandatory minimum would not be imposed.
That is so. But
so that immediately, you see, and one of the reasons why I suspect that the Plea Negotiations and Agreement Act should be utilized more, because once the DPP comes into the picture, the likelihood of a sentence being appealed further becomes almost, nil, because the parties would agree on a sentence in exchange for a guilty plea, which is the essence of the Plea Negotiation and Agreement Act. So, to be frank with you, DPP, my disappointment is that it is not utilized more. In other words, when we see in the United States, 95% of criminal cases are completed by plea negotiations. 95%. In fact, in some states, 98%. Now, and the truth about it is that because the penalties are high, huge, that many defendants literally, whatever is proposed by the prosecution, they just do a variation and get a guilty plea going very quickly. So I would hope that making sentence severe, as is what we're planning to do, that persons who are guilty could avoid the huge penalties by entering into negotiations under the Plea Negotiation and Agreement Act and get an appropriate sentence that fits the crime. In other words, it's not that if they plead guilty, they won't get the mandatory minimum or a high sentence, but at least the leeway would remain for them, especially where the murder is not as egregious, because the color or the range of murders are really wide. You have some where, it's a spur of the moment killing, as against those that are planned in advance. And so those can be taken into consideration in negotiating an appropriate sentence. Sorry to interrupt. I think you want to complete.
Outside of the plea negotiations.
I think DPP, you wanted to complete, but I just wanted to make that point so you can respond to it. That to the best of my understanding, it remains there unless we exclude it.
Well, that is so, Chair. But if I may be permitted to be frank, in the ideal world, it would be hoped that many people would see the wisdom of engaging in the Plea Negotiations Act in terms of assisting the Crown or the investigators so that they can get a lesser sentence.
Absolutely.
And all you would need is moral suasion or a pretty smile to get that cooperation. But in Jamaica today, you have a lot of communities where these accused persons come back, where the culture aids and abets criminality. And lawyers at the defense bar will tell you that you will speak to the client today, and they will come to us and we start to talk about possible sentences. And by tomorrow, if they are being kept at the university at Tower Street or Horizon, or even worse, they are on bail in their community. There will always be persons there who are wedded to criminality as a culture to advise them differently.
You know,
so one has to look at the human condition.
What you're saying is so true, and I'm sorry to keep interrupting you, and other members have some points. But I remember when I was at the bar practicing, and I encouraged a couple of fellows to plead guilty, and they were willing to plead guilty. But you know what they asked me? This is a murder, by the way. If they can get a suspended sentence. And they would only plead guilty if they could get a suspended sentence.
It's called a road sentence.
At which point I withdrew immediately. They were convicted and sentenced to life imprisonment. Now, the point I'm really making is that our attorneys need to just let their clients know that pleading guilty doesn't mean you're going to get away, but you may get a lesser sentence, which is not. People believe that from your plea guilty, you must get a road sentence. It's not on. Sorry about that, Dave.
But, you know, I'm just going to tell you a very brief story. I'm almost complete. I saw it on a file and spoke to the investigator in the gun court recently. Police came, and I'm not going to call the name of the community, but they had been having a series of gun holding up on the road. Police got a tip. They went to a home. Mother and the accused were there. They had the warrant, so they wanted to search because they have information that there's a gun in this yard. And the mother I read it on the file, was calling down the name of Jesus on the police and saying nothing like that. It would never happen. Not her son. Nobody here has any gun. The police executed the warrant and said they still wanted a search. And when they went to the back of the yard and they started to talk to the son away from the mother, the police officer said he's going to search everywhere. The accused man said, all right, I have a gun. I'm reading all of this. Okay, I'm going to tell you where it is. You can get the gun. All right, it's up. And he said to his mother, who was a little bit away, Mama, go show the policeman where me keep the gun. And she started, which gun? There is no gun here. And the young man said to his mother, Mama is all right. I tell the police officer. Carry him, go show him where we keep the gun. In the root of the mango tree, the hollow root. And there and then, she went in the present and took the gun from the gun was in a sack, right in the mango tree, and gave it to the police officer. The same lady who was bringing down the blood of Jesus on the police. Right? So I say this to say that it's all well and good, the beautiful lights of Parliament. Everybody here is educated. Everybody here has a moral compass that would say you assist investigation and the police. But there are some communities where the culture is informa fide, or you are a family, and even if you're a distant cousin, everybody close ranks and nobody has anything to say to the police.
Thank you, DPP. You're finished. Some members want to ask questions. Are you finished, DPP?
Yes, that's basically
I think Member Williams and then Member Daly and then others if you have a question. Go ahead.
So here comes the cross-examination.
Not really. Just an inquiry. Just to continue the process of you educating us and giving us your frank position on the matter. But my inquiry pertains, Madam DPP, to the Tafari Morrison case. And the question of, and I will just put the question. It's not a cross-examination question, but just to get some clarity. So, the position of the DPP is that the mandatory minimum of 20 should really apply in capital murder cases.
Yes.
And so this proposed mandatory minimum of 20 years could be viewed by the Privy Council as a violation of the Charter on the basis that that there may be circumstances where the sentence is grossly disproportionate. Is that the basis for you saying, you know, for your position that we would not apply it to children? And if so, how do we approach that via adults? You know, could there be cases where the Privy Council could also say, in the case of adults, that the mandatory of up to 50 could also be, 40 to 50 could also be disproportionate? I don't know if it's where I'm getting at. Whether this legislation could satisfy the constitutional test in all circumstances.
Well, Mr. Williams, as an attorney, you will know that the courts go according to the law and the evidence. You can't really speculate. Mm-hmm. And it was instructive if you look at the Tafari Morrison judgment. Mm-hmm. They were not prepared to put down an absolute, close all loopholes. Yes. Because you never know what is coming up ahead. What they were saying based on the circumstances here, and this was a child, in the circumstances of the case, mm-hmm. they were prepared to hold that the mandatory minimum here was proportional to the particular circumstances, mm-hmm. and it passed the test of the Constitution. But it didn't mean that they did not advert to the circumstances where perhaps there may be a situation where it may not pass muster, but it depends on the circumstances. And you know the usual, each case must be assessed on its own particular circumstances, which is why we are perhaps saying, in the unlikely event that you may have circumstances where the proportionality test and may segue into giving that loophole to possibly inhumane treatment, you use an amendment to section 42K. So from day one, and this is in respect of capital murder cases, where you would have the minimum mandatory. If the circumstances are of such that when you look at all the different reports, the psychiatrist report, the probation report, the social inquiry report, and it is quite clear that the young man, although he has killed 4 or 5 people, he was surrounded by pure antisocial circumstances, and that he was under the coercion of adults throughout in terms of a criminal lifestyle. Maybe, depending on what is recommended also by the psychiatrist, the courts can say, okay, in this case, it is highly unusual, and although the public interest is in agony and needs some sort of certainty in terms of what sentence is being given, so you cannot go below 20, but because of these special circumstances, we would ask that a certificate for these reasons be issued so that the sentence of 18 years before parole could be given instead of the mandatory minimum of 20.
Remember Dean?
This is why we're seeking to make sure that 42K is still preserved in relation to mandatory minimum if you are going to go that route for capital murder.
I see where you're going, but just a follow-up to that. So you're not saying, Madam DPP, that if a mandatory minimum of 20 years is imposed on children in other cases other than capital murder, other than in other murder cases, you're not saying that that imposition would fail the constitutionality test?
Well,
You're not saying that?
Well, we are saying ex abundante cautela, in an abundance
Okay,
of caution. We would not advise that. Because we have seen children in murder cases. As I said, we have 2 or 3 judgments of the court. And perhaps I will ask my Crown Counsel here to make it available so that Chairman, you and your members, honorable members, can see how the courts have sought to pronounce on children in conflict of the law as it relates to murder or manslaughter. And my recollection is that none of them have gone below 13 years. It was between 13 and 18 years. And that is non-capital murder. Which is why we are saying, if when you look at the case law, the particular sentences that are being given are between the range of 13 and 18 for non-capital murder. 20 years mandatory minimum for capital murder, we do not believe would offend at all.
Okay, thank you, DSC. Member Daly.
Thank you.
Thank you very much, Chairman. I hope we are not really just looking at all the lawyers in this committee.
Not at all.
We're also looking at some social workers and teachers.
Which is why we recommended, Miss, I'm sorry, could you remind me of your name, member?
Dennis.
Miss Daly, I'm so sorry.
Yes.
This is why, if you look at our written document, we did indicate that whether under non-capital or capital, in respect of a child, it has to be demonstrable that there will be an enhancement in the social work network and the corrections network of rehabilitation being stressed as it relates to child offenders. We did say that.
Yeah, I'm going to play the devil's advocate here now. Take, for instance...
Advocate, number the devil's advocate.
Take, for instance, you use this section of the Act, and another couple of years you find that you have children that you can't find space for in the institution. I just wanted to play that in your head. I'm going to ask, you being the same DDP, how and what would you recommend at that time? Just hold that for a second. But I'm going to start with part of your presentation and some of your pronouncements. 1, Chairman, if you have a child that is running a place, running it bigger than an adult, and that child is so equipped and sensible that that child I'm going to give you a chance to listen first.
No, proceed.
And that child is so active and smart that the child can do almost anything in the home. Would you allow that child by law to vote? To vote? That child would be able to vote? If a child is so smart that that child can do almost everything that an adult, and that child is running the adult's mind in terms of how they operate, would you give that child a work in a government system underage?
You're asking a political
no.
question.
I just all of these. It's not about, I tell you already, it's not about law. I just trying to look at some of the reasons given, and just to say that what in terms of this 20 year are we looking at for the end result? this mandatory 20-year sentences that we are now trying to establish, what are we expecting as a government, as a nation, to get at the end result? And I'm very happy because I thought you wanted to move the discretion of a judge. But in your last paragraph on your presentation, you said there is still room for some discretion. I believe this is not the place for me to make this kind of debate. But I really need to take in this House some reasons why I will not, and I do not believe in a 20 years sentencing for a child. If there's a definition for a child and there's a definition for an adult, I personally believe a child should be treated differently. And for that, I will debate whatever I can in the House, the lower house, which I represent, because I feel very strongly, I'm very emotional in terms of it, and I heard you speak about emotion. When you think about children, if there's no emotion attached, something is wrong with us as human beings. And therefore, I will still believe that there must be emotion. It cannot override us, but there must be emotions when we speak about children. And therefore, I believe there's a place for us to debate this matter, and I personally want to add to this debate because I'm very passionate about how we treat our children in this country, how we socialize our children in this country, and when it comes down to it, when we cannot manage, we try to look for the best solution out instead of dealing with the situation, because the community, you put one away.
Member Daly, you're right, but your position is what we will debate when the committee start to look at the actual legislation. Okay, so
I will go with your guidance.
Right. In other words, I don't think you need to persuade the DPP. Even if she disagrees with you, you will have the opportunity at the committee stage when we finish the presentation to review the actual legislation, whether we have no minimum mandatory or we reduce 20 to 1 year as the case may be, okay? So that debate will come after the presentation. I just hope that members are happy with the DPP presentation because we have 3 other presentations, and if there are no pressing questions for the DPP, we can move on. But
I'll go with that, Chairman.
Thank you very much, Member Daly. Senator Brown has a quick question. So does Senator Campbell. Let us speed it up because there are 3 other presentations we have this morning.
Good. Thank you. Mine are just 2 fact-based questions, Chair. First one is, I know Madam DPP has spoken about capital punishment, and you list a number of categories that qualify for capital punishment. And speaking to this jury, you seem to have left out the fact that murder parliamentarians also qualify.
I am so very sorry. I am so very sorry.
I just wanted to...
It was an oversight.
To be clear.
So very sorry.
And then the question. We have received information from some data from the Court Administration Division, and it points out that of accused murders, people under 17 and under, account for just 3% of the murders. And yes, it's a very high rate of murder in the country. But from your files, how many of these under 17 you are picking up to be involved in murder? And you could add whether any of them involved in multiple murders.
Well, we see children in conflict in the law, mainly in the gun court. In the gun court, or you may have some sort of domestic fracas, some domestic situation within the home, or we have seen several at school or on the way from school. Also, gun robberies as well, but usually in the gun court.
And you would agree with that's about 3% of all the murders?
Approximately, because we have only found...
information, the 3% is actually, you're getting it from here, right?
Yeah.
CAD provided
us.
That's what I
we would not be able to contradict CAD.
You would be able to contradict.
Yes.
Good, thanks.
Thank you, Mr. Chairman. And thank you, DPP, for your very thorough presentation, as usual. I was a little late, I apologize, but I was listening to your presentation on my way down. I have a question about note in your submission in relation to your recommendation that the rehabilitation framework and support systems for youth offenders be properly created to deal with youth offenders serving a mandatory minimum sentence for capital murder. I think it's paragraph 43 of your submission. And my question is whether your position on the mandatory minimum sentences would be the same in a situation where there was no such rehabilitative support framework?
It basically would be the same, but it doesn't mean that, okay, for example, we have had situations where you have youth offenders or youth complainants in criminal cases. And sometimes we have had to work with the children's advocate out of a concern that, you know, clearly from what we are seeing, something else is happening. So we would ask the children's advocate to intervene, or the other child agency. And sometimes I'm asked to enter a nolle, for example, where the child has been taken away by the parent who may still be in a relationship with the accused. And I will hold my hand until I get some update from an agency or the victim support to see what is happening with the child complainant. So you have a certain amount of flexibility. But if you could allow me, Chair, to answer Member Daly, when you are going to indict, even on your split screen, you may have some empathy or sympathy, whether for a complainant, a victim, or even the accused. That cannot play any part in your indicting, because by an extension of your reasoning, if we followed it to the logical conclusion, no child would ever be indicted for an offense. That is, well, if you followed it to the logical extension. But the thing is, when you look at sentencing, it has to deal with rehabilitation, punishment, deterrence, and retribution. You have a society, a community. And I can tell you, you don't want a situation where if there is a perception that in respect of heinous offenses, whether committed by a child or adult, the authorities are not putting the proper provisions in place, that you have jungle justice. As I said on the last occasion, I prosecuted a child for having raped, buggered, and strangled a 9-year-old, 50 pounds. And they were neighbors in a remote community in Westmoreland. And luckily, the family of the 9-year-old, they were God-fearing. They were God-fearing. Otherwise, there could have been jungle justice by the community. So if you don't have appropriate sentences in place that make sense to a community, you can unwittingly stoke a jungle justice fever where you have more murders being committed because there is a perception that the authorities are gone ahead on an emotional situation which is not allowing even children to take responsibility for their actions. I'm a human being. I'm a mother. But I'm an attorney.
Mr. Chairman, I'm sorry. I just want to complete my questions to the DPP, and I have a final one. DPP, on my way down, you were in the midst of the discussion about Section 42K. And I just, for my own edification, in practice, when that section is invoked and the judge issues the certificate and the defendant is then permitted to appeal the sentence, is there, in practice, is the sentence stayed until that appeal process is executed and completed, or are they, at that point, does the sentence begin?
Well, technically, if you're going to appeal, the sentence really doesn't commence until the appeal is heard. So usually you would be remanded in custody after sentence. So if a child is convicted...
After sentence or after conviction?
Sorry, after sentence. Because once you are convicted, then you move on to a sentencing hearing, where you would have the antecedent report, the social inquiry report, perhaps a medical report, psychiatric report, right? So after sentence, then you would be remanded in custody, but not to the institution necessary to commence the sentence, but you would be deprived of your liberty. So it's when the appeal is determined that the Court of Appeal would then say the appeal is dismissed, conviction affirmed, sentence substituted. Where you had the mandatory minimum of 20 years, we agree that it really ought to be 18 or 17. And it is reckoned, that is the word they use, the sentence is reckoned to commence as of 3 months after the original sentencing. Right. So if you have been incarcerated for 5 or 6 years, then that would be taken off.
But my understanding, DPP, is that in the past, the Court of Appeal would indicate that once you appeal, including sentence,
yes,
they have a complete discretion as to when.
That is it.
And it could be at the time of the appeal. But
it could be, but usually it's...
In recent years, they have been really not taking off the time served. While we're on that, and the last question to you, DPP, you have one, let me just finish this. In the case of minimum mandatory imposition, DPP, suppose a person have served, say, is in custody 3 years, anytime, before the actual conviction. Do you think that should, and a minimum mandatory is being imposed, do you think the time that they spent in custody before trial and conviction, that should reduce the minimum mandatory? At the moment, it doesn't, but the question, that's why I'm asking DPP, do you think it should be taken into consideration?
I think what usually happens, even if you have a mandatory minimum, say you have life imprisonment and you have a mandatory minimum, I think what the judges do in order to calculate when the parole period will commence, they still have to have a starting point from which they calculate down, taking into account the aggravating and the mitigating factors. And usually what the judges do, they take into account, in fixing the starting point, the number of years that you were incarcerated before trial. So they do take account of it, right, and then still come back to the mandatory minimum.
Thank you, DPP. Final question from Senator.
Yeah, that allows me, Chair, to make the link with the Tafari Morrison case that I wanted to make. Tafari Morrison committed the act in 2012. He pleaded guilty in 2013. That's 10 years ago. And got the mandatory minimum. Are you of the view that that mandatory minimum, which was eventually challenged and defeated at the Privy Council, that has acted as a detriment to other people committing, deterrent to other people committing murder and to children committing murder. Because that's essentially what we're trying to find out here. If a long sentence makes a difference. So Tafari Morrison provides us with that. The second point I want to make through you, Chair, that deterrent. The second point I want to make through you, Chair, is whether or not, given the inefficiencies in the administration of justice now, I cite, for example, the recent Privy Council, Ray Morgan. I cite another case that I know you were involved in personally at the Court of Appeal, Madam DPP. A firefighter who was found guilty, and then 10 years after, the records have not been produced. Whether or not, given that administration of justice, these flaws in the administration of justice, whether or not your approach to 42K makes much sense, because rather than allowing the judge to determine, we're now asking the judge to make a certification and for transcript and notes of evidence to come through. Why not leave it, that's the second, why not leave it with the judge in the circuit court to decide based on the evidence presented?
Well, the thing about it is that it's a policy prescription. I tell people all the time, and the judges will say it too, policy and the law is what Parliament says it is. So if it is that the policymakers and Parliament would wish to say to the public, listen, in this time of, a lot of murders, we recognize that the really heinous murders, capital murders, should be treated differently, whether you're an adult or a child. And this is our policy prescription. That is your policy prescription. But in respect of what effect it may or may not have in terms of social engineering, I am just a simple, humble prosecutor. So I would never be so presumptuous to go into that arena. And I'm a cricketer. I will not make. I will not play any googly.
Thank you very much. Thank you very much, DPP.
I leave it alone.
DPP, I want to thank you for your usual eloquence in presenting the DPP's contribution. So we want to thank you, and we note, and I'm sure it will come up when we have further discussion at the committee level. The Children's Advocate is with us, and if you're ready, Children's Advocate, you can start.
Thank you very much, Mr. Chair. Good morning to you and the members of this committee, and of course my colleagues who are here. Certainly it is my privilege, I deem it, to be here to address the Joint Select Committee on the issues surrounding the imposition of a mandatory minimum in relation to children. It is a settled fact that the Children's Advocate and the office that I lead has as its primary focus issues which actually or may in fact impact upon children. And against that background, I welcome the invitation to make this particular submission. I want to say as well, Mr. Chair and members of the committee, that because the Office of the Children's Advocate is so vested in terms of all matters concerning the Child Care and Protection Act, I have quite a number of views and quite a number of positions, but in the interest of time and for the purpose of relevance, I've made my submission particularly pointed and have narrowed and confined my thoughts to the particular issue at bar. And I say that because I know that there are very many public commentaries now on the entire reassessment that needs to be done of the Child Care and Protection Act. And I too stand by those, but this is not the committee for that. And so I've narrowed my views. Now, the particular amendment or proposed amendment that falls before us concerns the Child Care and Protection Act the Offences Against the Person Act, and the Criminal Justice Administration Act, all amendment acts as proposed of 2023. And the particular reasons that have grounded this approach, as stated in the Memorandum of Objects and Reasons, are that it concerns an uncontrolled and unabated murder rate that ranks highest among 22 Latin American and Caribbean countries. And that's, of course, describing Jamaica's current situation in terms of our crime rate. So it's a very serious issue, to say the least. Now, in terms of the primary issue, as far as the Office of the Children's Advocate sees it, is that it concerns the proposed tariff of a child having to serve a minimum of 20 years before being eligible for parole if convicted for the offense of murder. As a consequence, these submissions will focus initially on the proposed amendment to the Child Care and Protection Act, and thereafter will make passing comment in relation to the Offences Against the Person Act and the Criminal Justice Administration Act. Now, if you could focus on the proposed amendment of Section 78.3 of the CCPA, and of course, this section treats with restrictions on the types of punishment that legally can be meted out to a person once it is established that he or she is a child. And of course, we all know that a child in Jamaica is defined as being a person under 18 years, and that is consistent with the United Nations Convention on the Rights of the Child, of which Jamaica is a state party. As provided under the current Act, the discretion lies within the presiding judge to determine how long a child should be imprisoned before becoming eligible for parole. This discretion is unfettered currently, as it does not bind the judge to a mandatory period that must be observed when sentence is being contemplated for a child in relation to any offense, and of course that includes murder. In contrast, however, is the proposed amendment which imposes an obligatory minimum period of 20 years that the judge would be compelled to abide by when treating with the matter of sentencing a child for the offense of murder. These submissions, and certainly the Children's Advocate, well understand the gravity of Jamaica's national criminal circumstances, and we do take note of the gruesome murders that have been recorded in our country. The Office of the Children's Advocate is also aware, regrettably, that there are persons under 18 years of age who sometimes feature as accused persons, and persons who are convicted of these murders, and as a consequence, contribute to the high crime rate with which we now have to contend. An appropriate response is therefore necessary. There is one comprehensive recommendation that the office puts forward, and we have enumerated 5 bases on which we seek to justify that recommendation. And the recommendation is that the imposition of the need for a child to serve 20 years before becoming eligible for parole needs to be qualified or tempered by way of the incorporation of a proviso into the amended Section 78.3 of the Child Care and Protection Act. It is recommended that this general proviso be triggered whenever the trial judge forms the view that the individual circumstances of the child offender warrant an exception to the mandatory minimum of 20 years before being eligible for parole. Further, it is recommended that a sentencing hearing in which the judge considers arguments of whether the case at bar warrants the 20-year minimum or if this should be deviated from may prove to be of tremendous benefit in cases of this nature. In the face of needing to balance Jamaica's struggle with high crime on the one hand and the special considerations which do attach to juvenile offenders and which we must not deviate from fully, such a hearing may present a useful compromise when we have to deal with these matters. Now, I pause here, Mr. Chair, to comment very briefly on Section 42K that the Learned Director has spoken to in relation to having the right of an appeal once the reasons are given. It is my preferred view that even though Section 42K should remain, because there are other offenders that the Criminal Justice Administration Act treats with, I think that if we go the route of having a proviso, which allows the discretion of the judge to still be invoked in circumstances where it is appropriate, then we would not run the risk of having a child with nuanced circumstances go through the entire criminal justice process and at the end, following a conviction and sentence, then have to face the usual consequence of an appeal. The basis for this particular proposal, which is that we want a proviso, there are 5 facts, as I said, or just bases on which I seek to justify. The first is the best interest principle. A judge who presides over any matter involving a minor, that is a person under 18 years, has a duty to act in accordance with the best interest of the individual child who stands before him. This duty extends to the sentencing phase of the proceedings, and if the judge's hands are figuratively tied when considering the sentence, he is barred from fully exercising his discretion despite the circumstances of the particular child. Section 65 of the Child Care and Protection Act states in part, and I quote, "Every court in dealing with a child who is brought before it, either as being in need of care and protection or as an offender or otherwise, shall have regard to the best interests of the child." Now, it is noted as well, Mr. Chair, that Section 65 is not the only section that provides for the best interest principle to be taken into account when dealing with a child. Other sections of the CCPA are consistent in recognizing that this best interest principle is the prevailing factor that is taken into account or ought to be taken into account in all decisions made with regard to children in various circumstances, including those children in conflict with the law. I refer to Section 65 further, and again speak about just how it really puts the best interest principle in the center of considerations. And what it does, that is Section 65, is it infuses into Jamaican law the principle articulated in Article 3 of the UN Convention on the Rights of the Child, a convention, as I said before, that Jamaica is a state party to, and I dare add we're a pioneer within the Caribbean region in this particular regard. The text of Article 3, Paragraph 1 of the Convention on the Rights of the Child provides, "In all actions concerning children, whether undertaken by public or private social welfare institutions," and my emphasis, undertaken by courts of law, administrative authorities, and again my emphasis, or legislative bodies, including this Honorable Parliament, the best interests of the child shall be a primary consideration. And of course, as Council, Mr. Chair, and several members of the committee, we all know that the word shall imposes an obligation and not a discretion. The second basis on which I seek to justify that a proviso needs to be infused into the proposed amendment has to do with the need to have the assessment of the individual child be a focal point of any court's consideration. This, of course, perhaps is a direct corollary to the best interest principle, in that a child must be considered and assessed as an individual. That is, his or her particular circumstances have to be weighed by any decision maker, including the court, who proposes to act in that child's best interests. This requirement does not shift when treating with a child in conflict with the law. And in fact, Section 3 of the Child Care and Protection Act has stipulated the need to recognize the special circumstances of children in conflict with the law and binds all of us to answer a higher duty or calling when treating with that cohort of our children. Now, this means that because the requirement does not shift when treating with a child in conflict with the law, it would naturally extend to the sentencing phase of any case involving such a child. Section 70, Paragraph 1 of the Child Care and Protection Act provides that where a child who is charged for an offense is to be brought before any court at all, a notice of the grounds on which he is so brought shall be served on the probation and aftercare officer and also the children's advocate. The purpose of this notice is elaborated upon in Section 73 of the CCPA, which articulates as follows. Upon the receipt of the notice, it shall be the duty of the probation and aftercare officer on whom it is served to make such investigations and render available to the court such information as to the child's home surroundings, school record, age, health, and character as the probation and aftercare officer is able to obtain, and as, in his opinion, is likely to be of assistance to the court. Mr. Chairman and your members, if therefore a mandatory minimum sentence is imposed by the legislature upon a judge, then the provisions of Section 70, paragraph 3 become nugatory and irrelevant when treating with a case of murder. This is so as even if the findings of the probation and aftercare officer would have led the judge to recommend a term of imprisonment that falls below the 20 years that is being proposed, that judge would be rendered incapable of imposing a sentence which the justice of that situation would have demanded. Consequently, a minor who is so recalcitrant a character, particularly hardened, and who has been convicted of having committed a most egregious murder, would be starting at the same point as a child who may be convicted of murder in circumstances which would be more amenable to a more lenient sentence than that which is allowed by the mandatory minimum. In much the same vein as this argument, Lord Justice Kennedy, in the case of the Queen against the Secretary of State for the Home Department, cited at 2001 for All England Reports, page 934, this was a case that was heard in the Queen's Bench Division of the Court of Appeal, of course in the UK, and it described a mandatory sentence in the following terms. A mandatory minimum sentence can be described as one that has been imposed, irrespective of the individual circumstances of the offender or the crime. It has been imposed on offenders of widely differing culpability. It imposes a far greater punishment on those convicted of murder, even in circumstances where the borderline between murder and manslaughter has just only been passed and serves no penological purpose. The third basis, therefore, on which I justify the proposal that we need to have a proviso is the utility of a social inquiry report. It has long been established in Jamaican courts that to obtain a pre-sentence social inquiry report which presents a more comprehensive picture of who the offender is to recommend or is recommended best practice. In the decision of Michael Evans against the Queen, a Court of Appeal decision, Judge of Appeal MacDonald Bishop, in delivering the decision of the court, opined, "We do recognize the utility of social inquiry reports in sentencing and cannot downplay their importance to the process. Indeed, obtaining a social inquiry report before sentencing an offender is accepted as being a good sentencing practice. The mandatory minimum, therefore, Mr. Chair, especially with regard to minors, erases the utility of social inquiry reports and goes against the position of our own Court of Appeal." The fourth basis on which I justify the proposal for a proviso has to do with the objectives of juvenile justice. Now, I agree with the learned DPP when she cites the purposes of a sentence. But I also want to put on the table very squarely the special considerations when treating with the issue of juvenile justice. And the overarching goal of juvenile justice is not just rehabilitation of young offenders, but there's also the ultimate objective of having them reintegrated into society because of the benefit of youth and because of how effective our rehabilitative methods need to be. We foresee that if rehabilitation is working as it should, then the ultimate objective of having young offenders reintegrated into society as productive members who are able to meaningfully contribute to the society's growth and development has to be a purpose that we bear at the forefront of our minds at all times. This position is confirmed in Article 40 of the Convention on the Rights of the Child, which focuses on the administration of juvenile justice, and its text in part states as follows. States parties recognize the right of every child who has been alleged as, accused of, or recognized as having actually infringed the penal law to be treated in a manner which takes into account the child's age and the desirability of promoting the child's reintegration and the child's assuming a constructive role in society. Mr. Chair and your members, to impose a long sentence, therefore, especially in circumstances where the judge, in weighing all the circumstances of the particular child offender, forms the view that the child ought to serve a term less than 20 years, would be to unnecessarily expose that child to hardened criminals for an extended period. To use the words of the DPP, and being a former prosecutor myself, I'm very familiar with the term about the university at Tower Street. And so what we're saying is if we confine children without any particular consideration as to their circumstances to what really is a university of crime, it means that we are molding them into even harder criminals. Not only, therefore, would this adversely affect that child's prospects of being reintegrated into society in a timely fashion, it would also have a potentially debilitating effect of increasing the number of individuals with a propensity towards criminogenic activities in our society. Of course, that's the last result that we want. Instead of rehabilitating those cohorts who are amenable to rehabilitation, therefore, the criminal justice system would have unintentionally contributed to the growth of that population of persons with deviant behavior in the society, thereby compounding the criminal problem that we're trying to address. The fifth and last basis on which I seek to justify the imposition of a proviso is the fact that an imprisonment of a child is to be for the shortest appropriate period of time. And I emphasize the word appropriate because let it not be misunderstood that we don't understand that in certain circumstances, a term of imprisonment may be what is appropriate. But what we're saying is that that term should be for the shortest appropriate period of time. I refer to Article 37 of the Convention on the Rights of the Child, which stipulates as follows: the arrest, detention, or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort, and I emphasize last resort, and for the shortest appropriate period of time. Appropriateness and the proportionality of a sentence with respect cannot be predetermined by a judge prior to him being seized of the facts of the case and the particular circumstances of the child offender. Factors such as the child's age, social circumstances, and the influences that may have operated on his or her mind at the material time should be taken into the judge's assessment and ultimate determination of what sentence is most appropriate. These factors, Mr. Chair and members, would be factors that would be put forward in a social inquiry report. And of course, not only has our Court of Appeal pronounced on the usefulness of those reports, but we have a practice that even when the offender is not a minor, but is considered youthful, 23 or so, that the courts encourage that a social inquiry report is prepared and presented so that the factors that are peculiar to the offender can be taken into account. And so we strongly believe that a mandatory minimum makes this consideration of the individual who appears before the court unachievable. The United Nations Standard Minimum Rules for the Administration of Juvenile Justice, more popularly referred to as the Beijing Rules, is also in support of this position, as it stipulates that the reaction of judicial and other authorities to juvenile offenders should be in proportion to the circumstances of the offender and the offense. And it doesn't make a distinction whether it's murder or otherwise. Specifically, in Rules 6 and 8, the Beijing Rules speak to the requirement for justice systems to be sensitive and flexible because of the special needs of children and their vulnerabilities, and that discretion is to be applied at all stages of proceedings and all levels of the justice system. And of course, all stages of the proceedings would include at the stage of sentencing. And so, for the purpose of emphasizing, Mr. Chair, and concluding, the proposal of the Office of the Children's Advocate is that a proviso be built in to the new Section 78(3) of the CCPA, and this proviso ought to be triggered whenever the trial judge forms the view that the individual circumstances of the child offender who appears before him or her warrants that there should be an exception to the mandatory minimum of 20 years. And then, of course, as obtains now in matters that would previously be just routinely leading to a sentence of death, that there also be a sentencing hearing when the judge would get all the assistance that he or she may need to understand the circumstances of the offender, to understand whether this is a borderline murder versus manslaughter, to understand whether the child is being used as a pawn in the particular commission of the offense, and to have a nuanced position that sees that child as an individual as opposed to a warehousing position, which is what we are suggesting that the mandatory minimum would impose on all children in relation to the offense of murder.
Thank you very much, Mrs. Sarson. I know members have some questions, but let me just use chairman privilege to ask a couple. If the victim is a child, you agree the most severe punishment should be imposed if the offender is an adult?
I believe, Mr. Chair, that if the victim is a child, that certainly is an aggravating factor that the particular court needs to take into consideration in determining what is the appropriate sentence. And again, rely on the judge's discretion to see it as an aggravating factor.
If the offender is an adult,
yes,
there should be, there's nothing, none of what you have said should apply if the offender is an adult.
I wouldn't say none of it, Mr. Chair. What I would say is, being an officer of the court myself and understanding the importance of each case turning on its own merits, I would say that the particular prosecutor who is leading the charge in that case should make very heavy weather of the fact that the victim is a child, and should prey upon the court that this now would be one of the most aggravating set of circumstances, but the discretion lies within the breast of the court.
The challenge, you see, Mrs. Sarson, is policymakers have to balance the interest, the public interest, because in many ways the public interests have no doubt that children must be protected. So when the victim is a child, the public interest is demanding the most severe punishment for the offender if the offender is an adult. Now, what you have said is if the offender is a child, then we must look to the best interest of the child. But at the same time, we have to balance the victim.
Agreed, Mr. Chair.
Especially if the victim is another child. And the point there is, how do we balance the demand of the victim's family in particular, who in many cases don't care about the offender. They care about what is that victim justice going to be, whether it should not have some element of retribution, denunciation, you know, deterrent, so that no other child should be killed, whether by another child or an adult offender. So wouldn't you say that in looking at the best interests of the child, you cannot ignore the sentiments of the victim, especially if it is another child?
Yes, I agree with that, Mr. Chair, which is why my position is nuanced. I've not said no to a mandatory minimum. What I've said is that let the mandatory minimum stay, because we understand the very high crime rate and the position that Jamaica finds itself in terms of, you know, all sorts of descriptions about murder capital and so on. But what I'm saying at the same time is that to balance it, we have to give the judges some amount of discretion to look at the particular case that falls before him or her for determination. Right. So what my position is saying is, all right, yes, we have the mandatory minimum, but also ensure that at the time of sentencing, if the justice of the situation demands that there is a sentence that is below 20 years, the judge should not be barred from acting in accordance with the justice of the situation.
All right. Thank you very much, Mr. Harrison. Any very pressing question? Otherwise, Mrs. Harrison's presentation was quite comprehensive. Because we have 2 more presentations, we're going to try and have some quick questions.
Well, I just wanted...
Sorry, go ahead, Donna.
No, go
ahead, Senator Motley.
I just wanted to commend the Children's Advocate on a very balanced presentation, which takes into account the fact that there are circumstances where the mandatory minimum might be appropriate, but leaves the window open so that the judge can exercise the discretion when it is not.
Yes.
The DPP gave us some examples, both last week and this week, which made us shudder. But there are equally circumstances where, as you say, it just goes a little bit beyond manslaughter. And where a child has a brilliant future, actually, and is usually normally well behaved, but in this moment has lost control. That person, that child, needs to have an opportunity to, in spite of paying the price, which we all must do, of committing an offense, to be rehabilitated and to be able to join the society, having paid that price. I think that certainly is my position.
Yes. And
I thank you for supporting it with examples of where and you said it very interestingly that Jamaica has led with the UN position for the protection of Convention on the Rights of the Child.
Yes.
It is interesting that you should remind us now,
yes,
on this occasion, that we took a position on that. And I just wanted to thank you.
Thank you very much, Member.
Senator Campbell.
Chair, I too appreciated the Children's Advocate's presentation. Thank you for the thoroughness that I know you always deliver. I have a question in relation to what I deem to be the position taken by the DPP and the proposal that you have made in relation to the proviso. And it is this. Well, the section 42K, and I'm not quite sure yet who I'm landing it on, but section 42K, which allows the judge to issue the certificate to permit an appeal against the sentence. can any of you shed any light on how long a process in reality that tends to take from the moment that that certificate is issued until that appeal is heard? What kind of time are we talking about in the system?
Well, from my perspective, it's a very involved process. I mean, you have 14 days within which to indicate whether you intend to appeal, but the timeline between when you make that intention known and then file the appeal and it being listed in the Court of Appeal for hearing, certainly from my experience, can take as much as 2 years. I don't know if the DPP wants to add to that, but it's not an immediate process. And so from where I sit, that's why I said in my submissions that for the child who goes through the entire process, gets convicted, is sentenced, and then has to then further engage the formal criminal justice process for an appeal to be heard, where you're dealing with perhaps a nuanced situation, borderline manslaughter, that would be a particularly onerous reality that that child would face. And so I prefer to put the horse before the cart, which is to have the proviso so that before the sentence is passed, the judge can be assisted with all of the circumstances that attend upon that child and give what is deemed appropriate if those circumstances require going below the minimum.
Just for information, Senator Campbell, I know appeals are taking a long time because of transcript, but very shortly, and I hope very shortly, technology will allow us to have transcript ready in hours or days rather than years, because the technology is available.
Are you talking O.J. Simpson days? Are you talking O.J. Simpson days or some future
Thank you,
days?
Mr. Chair.
All I'm really saying is that the technology is now being put in place so that the transcript can be ready almost immediately.
Thank you, Mr. Chair. Just to be clear, though, Mrs. Harrison, are you saying that it takes 2 years to be listed in the Court of Appeal, or 2 years for the matter to be heard and completed at the Court of Appeal?
I think for the appellate process before the Court of Appeal to commence. And I'm speaking very loosely.
To commence.
But it's certainly not within 3 months or 5 months. I don't think I've ever seen that.
And since I don't have anything called vast experience at the Court of Appeal, how long does it take for the matter to be heard once commenced at the Court of Appeal? Is it...
Yes, well, the Court of Appeal is particularly efficient. So once you are before the court and your case is being argued, the court is particularly efficient in terms of how matters are set and how matters are dispatched.
Thanks, members. We want to give the other presenters a chance.
I just have a quick question.
A quick question, because we want to give the other presenters.
On page 6 of your presentation, Madam Children's Advocate, you spoke to the appropriateness and proportionality of sentence cannot be predetermined by the judiciary. Do you share the view that it should not be predetermined by the other co-equal branch, the legislature?
I do, Member
Thanks
Brown.
very much.
Yeah.
Okay, thank you very much, Children's Advocate, Mrs. Diana.
Chairman, just a quick note. Thank you for your contribution, Children's Advocate Diana. That there's 2 other comments regarding the other 2 acts that in your submission.
It is available to members. Okay, just note that the presentations have all been put. They are available. Okay. And in fact, the next presentation we are going to ask is for the Youth Advocacy Network to do their presentation. And I'm told you have a PowerPoint presentation. We have the presentation, so I'm going to ask you, in the interest of time, to just highlight the issues you move from screen to screen, okay?
Okay, no problem. I hope I'm able to effectively do that. All right, I'll skip over whatever introduction or objectives that we had. My name is Sharika Mills. I'm the Policy and Advocacy Coordinator at Jamaica Youth Advocacy Network, and I'm joined by Kayla Wright. She's our Policy Assistant at Jamaica Youth Advocacy Network. Okay, so I'll skip over introduction and also our objectives as you have them there. All right, so as our position is that we are generally opposed to mandatory minimum sentences. We think that everyone should have the right to be heard before the court. But as our particular mandate is related to children and young people, we are more concerned about those minimum sentences that relate to child offenders than we are so much about the others. And so we'll focus on children today. All right, and so firstly, we take note of the memorandum of objects and reasons that would have given some justifications for the particularly punitive nature of the amendment. And the Office of the Children's Advocate would have just mentioned one, which was in relation to the uncontrolled and unabated murder rate. And so we wanted to get some kind of idea of whether mandatory minimum sentences was working in other areas to disincentivize persons from committing crimes. And so we actually did an ATI request to, I hope I can bring it up, to the JCF, and our question was whether since the Firearms Act was passed at the end of last year, whether the numbers of arrests or charges went down to indicate whether persons were still incentivized to commit these crimes in the same way or in an increasing manner than before. And we actually saw that for every single one of the offenses that the arrests and charges had increased. And we especially took note of possession of a prohibited weapon, which has a mandatory minimum sentence currently of 15 years, and that actually more than doubled the amount. Just for the first 6 months of this year, the 2023 statistic is related to. Meanwhile, the 2022 statistic would have been related to the entire year. So already just in the first 6 months, we have more than doubled the arrests and charges for this, even though we have recently implemented a minimum sentence for this offense. And so we are asking, why are we continuing to implement the minimum sentences when we are not sure that they work or that they are effective, especially in our context? And we think it's even worrying because the effectiveness of the solution hasn't been demonstrated, but then we are sentencing children to this kind of severe punishment, and we also have uncertainties about the effectiveness. We don't think that that should be something that's allowed. All right,
Mr. Chairman, can I just ask if you could just pull the mic a little closer to you? It's sometimes difficult to hear it.
Maybe I can sit closer. Okay. All right. Your second justification was as to the adverse impact of crime and on domestic safety, that should be. But we wanted to also urge you to consider that these children, as perpetrators of crime, are also victims of crime. That they, even while they are perpetrators, that they are still victims because of the impact that criminal activity will have on their lives. And that this is not something that means that they should not receive a sentence that's proportionate to the crime that they have committed, but that that should also be considered in the way that we deal with them and in the variety of orders that we would give. Because as you will see in our recommendations, we don't think that imprisonment is the only order that should be given, and we even would say that in no circumstance related to a child that imprisonment should be the only order that's given, but it should be complemented by other orders that would aid their rehabilitation and reintegration, and that we should perhaps expand the amount of orders or the types of orders that judges are able to make in this instance, so that we can have orders that more effectively considers the holistic child, you know, and not just them in this moment of their lives as offenders. All right, where am I? All right, then we want to talk about the evolving capacity of the child. As we have heard multiple times here today, children are used as, as the DPP said just now, as candy. And we think that should be something that's considered. We should give judges the opportunity to consider that when children are used in this kind of way, that we should not punish them as though they were independent agents. But we should have some consideration of that, and that should be taken as a mitigating factor to decide what the final order is. And so we think the evolving capacity of the child is a widely accepted principle that we have also used in our context to inform and guide decisions related to child development and even to develop legislation. And we should not ignore that concept now. All right, so I think we can skip here. So we're saying children who commit offenses definitely bear responsibility for their actions. We are not saying that children should not bear any kind of responsibility for their actions. But especially depending on their stage of development, we know the age of criminal liability, and this amendment has also not differentiated between, you know, what will happen to a child who is perhaps 17 versus how a child who is 14, 15 will be treated, or whether there will be any difference in that age. And so depending on their stage of development, it does require consideration of their circumstances to make an appropriate order, because how are we fairly determining how liable they are without even considering their capacity to commit the crime that they have committed? All right, and then we also wanted to bring up the Morris and the King case that's been brought up a lot already today. And in that case, the Privy Council would have stated that it was reluctant to incorporate the standards found in international law directly into Jamaican law because they did not feel that the Jamaican legislature had expressly incorporated international law for the protection of children into domestic legislation. And so we acknowledge that we do have that wide constitutional protection for children, but we can't ignore why this decision was taken. Yes, the mandatory minimum sentence was not held to be constitutional, but that was because of our sentencing policy towards children. They could not interpret the constitutional protection to be so wide because we obviously had never intended for it to be so wide, and so they could not bring that interpretation to our context. And so we cannot just sit here and say, oh, well, it's not unconstitutional. We also have to look at why that decision was taken and whether there's anything that we can do to offer children better protection, even though this is the decision that was taken. And so I wanted to highlight some of the Privy Council's remarks that, you know, the decision of the legislature to impose minimum sentences on children for certain crimes involving firearms in July 2010, because that would have been the feature of that particular case, demonstrates a positive legislative decision not to implement those features of the UNCRC, that's the Convention on the Rights of the Child, requiring detention of children for the shortest possible time. And it is also striking that the commission referencing the Constitutional Commission within these provisions does not mention the Convention on the Rights of the Child, which had been ratified by Jamaica approximately 3 years before its final report. And we want to ask, what of the reputational damage to the country when these are the remarks made about us in the international sphere, that we are not a country that is, you know, going by our international obligations and incorporating the international standards as we should? And what's there to be said of that reputational damage when we consider that we are not respecting the rights of children enough to make them actionable and to actually do the things that we said we were going to do when we signed on to these international conventions? And so generally our view is that for these justifications that were listed, that we don't think that on their own or combined that they justify or general attitudes when it comes to sentencing children, that we know deterrence and punishments are important objectives of sentencing, but they're not the only objectives. And in the case of children, as was spoken about before, a balance definitely has to be struck between those objectives, that of rehabilitation, and also reintegration, as the Office of the Children's Advocate would have mentioned. And so the objectives to deter and punish continue to exist. But how are we as a society and as a legislature going to consider the realities that we have here and consider how we can make sentencing and how we can, you know, have other orders that actually speak to our reality? And we have some recommendations. I'm also going to skip through this section because it is important to consider these rights, but the Office of the Children's Advocate did a really good job at going through all of the things that we had here, and so I can skip through here. Yeah, they would have. Okay, and so our recommendations are that. Okay, we don't think that the amendments to the Act should be passed. We don't think this is the right way to go about sentencing children. We think that judicial discretion should be maintained as it is now, even though there are other things, as we will suggest, that we could do to make it better or to appreciate the justifications that were given earlier. And so we don't think legislators should interfere with the rights of offenders of whatever age to be fully heard before the courts, not interfere with the role of judges to fully adjudicate a case on its merits and to have the final decision as to what orders are appropriate. We think these considerations should be added to the list of considerations involving child offenders, age, the possibility of rehabilitation, that's something we should look into, and whether they have been groomed into a life of crime as mitigating factors. And judges should also be able to make care, guidance, and supervision orders, community service orders, orders to participate in group or other forms of counseling, orders concerning schooling. And so we should think more holistically about the kinds of orders we can make to improve this child's life. In every case, we know that the social inquiry report is produced, and we've heard that a lot today as well. And so the report must involve an assessment of their level of responsibility and maturity in the circumstances of the specific offender. And so because we know that children are usually used, as was mentioned earlier, as candy in these cases, we think that perhaps these reports should try to figure out whether this is the case, since we know that it's happening so frequently. And so the report should involve some kind of assessment of their level of responsibility and maturity to give some kind of opinion as to whether they could have independently acted or in what circumstances that they could have independently carried this out. All right. Wherever possible, in the case of children, a sentence of imprisonment should be avoided, especially in the case of a first offender. It should be considered as a measure of last resort, where no sentence or other order can be considered appropriate. And so we go back to what was...
You would maintain that position even for murder? Even for murder?
Yes.
That you could get a suspended sentence? That you could get a non-custodial sentence?
If that is the judge's final decision, then that is something that we would also accept. But we maintain that this is the way that they should consider.
You don't think that would be inspiring jungle justice?
No, what was that? I'm sorry.
You would think if a young child is convicted for murder, and the judge, in their discretion, taking everything into consideration, gives a non-custodial sentence, be it a suspended sentence, don't you think it would attract retaliation, retaliatory justice from the victim's family?
I mean, I cannot say, but I think if that's the reality, then we should seek to prevent that reality.
It's exactly what we're trying to do here. By saying we have to balance, you see, the sentiments and the feelings of the victims. So I'm not saying that there may not be appropriate cases where the child is not sent to custody. But when it is murder, remember that there are persons out there hurting. And the question is, how do we balance that hurt? I can understand for other crimes, but especially for murder, you will understand it would be the most unusual situation where the offender is released back into the community without some form of custodial sentence. Wouldn't you agree with that?
No, I do understand what you're saying, and we do take kindly to the recommendation made by the DPP, not the DPP, the Office of the Children's Advocate, for some kind of proviso in those kinds of instances. But we think that this needs to be the thinking around the children. Even if we come to the final decision that imprisonment will be what we will do, the starting point needs to be, maybe this isn't what we should do. And if we end up coming to that position that this is what we are going to decide to do to imprison this child, then okay, but that cannot be where we start, is our position. That it has to be depending on the circumstances. And we think imprisonment should not be made on its own as an order. So even if we are coming to that position to imprison the child, it should be complemented by other orders that will promote the child's rehabilitation. So maybe they should do some mandatory counseling. I think this is probably the final 2 points. So where imprisonment is considered appropriate, because we acknowledge that that's definitely a reality. It should be for the shortest possible period of time. I think the OCA's words were appropriate. We'd also say that. Allowing judges to consider the nature and gravity of the offense and the needs of society, as well as the particular needs and interests of the child offender. So balancing all of that to recognize that when the child becomes an offender, they do not lose that empathy from us still. That we understand what they have done is serious, but we do understand that we should treat with them differently. And so their needs and interests do still need to be considered if we're serious about rehabilitation and reintegration. And so judges should also be guided to structure the punishment in such a way as to promote the rehabilitation and reintegration of the child concerned into his or her family or the community and society, whatever those orders will look like in the particular case.
Thank you very much. Remember, Daly, you wanted to ask?
You know, while the presenter was making her presentation, I thought about it. And that word rehabilitation, which I believe into so much, came up. And the children's advocate spoke about it as well. A child at 14 commits murder, one that would have merited the section of 42K. Where would you send that child? Because I've told that there's a university that is at Horizon, Tower Street, all the other places. Are we going to send these children to those universities? Or do we have a place? Because, you know, we're making all of these things, but we do not have the facilities to accommodate. So in their presentation, I don't believe that you should eliminate the fact that we might have to use this in extreme cases if it warrants. However, I still believe you should be looking at where would you send that child.
Go ahead.
Okay. The primary purpose of making that kind of recommendation too is because of what we know to be the reality in these facilities, that once they are there, then rehabilitation becomes something that's, you know, no longer such a bright reality as it was when they just entered. And so that is primarily why we want imprisonment to be something that we don't think about as where we begin, but something that we can arrive to, but that we don't think about as where we begin. Because then, especially for children at that early age, the possibility for rehabilitation and reintegration in the facilities that we have, it's very little. So
thank you very much. Thank you very much for your presentation. One thing I would like, you want, go ahead, Senator.
Thank you, like we thank the others for their presentation. Jamaica Youth Advocate Network, you have the view that while Jamaica signed on the Conventional Right for Children, we are breaching it with a mandatory minimum sentence for children. That is to say, Jamaica is not fulfilling our obligation to the conventional right to the child, which we have signed on. Is that the position being advocated? Thank you.
Okay, I want to thank you very much for your presentation. I did glance through your presentation, and one of the points you made was the legislature should not get involved with the sentencing of children because the judges are capable. But, sorry, go ahead.
I wouldn't say not involved. I don't think it's not involved because I think there are ways that we can guide judges to make appropriate orders, and we had listed some of them. So I wouldn't say that we shouldn't be that legislature shouldn't be involved. I think it shouldn't be completely within your control, removing the judicial.
Why I mentioned this to see is that the legislatures are in the best position to know what is happening in the society. Not that judges don't, but the legislature has to take the public interests primarily into consideration. And just for the history, the reason why the state took on prosecution of offenders is primarily to avoid retaliatory justice. Because if you left it up to the victims and their families to get justice, it would be purely retaliation. So that is why, although we look at rehabilitation, restoration, you know, and for the offender, we cannot ignore the expectation of victims that their sentiments and their justice must be taken into consideration. You see the point I'm making? So to the extent...
I do see your point. But I do find it interesting that it's that the persons, I find that the people who are on the other side of this argument to say, you know, we should not immediately criminalize children are made out to be the ones that are emotional and are taking emotions into consideration. But then this consideration is heavily based on the victim's emotion and what they would want to be the outcome in the case. So I find that to be quite interesting.
As legislators, we have to make reason assume its seat. Anyway, we're going to take the last...
Chairman, I can't make that pass. The Bible says a little child shall lead us, and I am being led here by the view which says the legislator may make the final decision, but they must listen to the people who they invite to come before them. And I am very happy to listen to all the presenters.
And sorry,
before I make any decision.
No, but I agree with you totally. We're listening.
Chair, one question of you, sir. Do you have any evidence of this jungle justice or this retaliatory work? I mean, do we have real data about it? Have we examined the instances? Have we, please allow me, member. Do we have any documented instances that we can actually say it is because of the failure of somebody to go to jail or to get 20 years that somebody reacted?
There's no doubt. Let me say this. There is good evidence where the sentence is not, where a person having been given a low sentence, that the family wait on him to come out. Wait on him to come out, and as soon as he comes out, you know how many inmates within a week after going outside are executed. So you know the point I'm really making.
Chair,
if the sentence is not appropriate and fits the crime, we leave a vacuum.
But Chair, the DPP said that the family of that 9-year-old child who was dealt with, horribly murdered, said they were people of God. So why, and there are many instances that I have seen reported where people say, I am not happy with the sentence, nobody is going to be. But say, I understand, or I forgive.
You know, Senator Motley.
So the point is, the point I'm asking is, where do you get the sense that as a result of a low sentence, we have jungle justice?
Senator Motley, may I just make the point? If you ask the country right now if the death penalty should be imposed, 98% of them would say yes. 98% would say yes. Right? I am, and to be frank with you, I'm one of the 2%. We need to move on. The Child Watch Legal, where are you?
Good afternoon.
Yes, I'm sorry, we're only going to give you not more than 20 minutes. Okay, so please summarize as much as you can.
Not a problem. Thank you, Chair, and to all the members of the Joint Select Committee and to my colleagues that are here. I am Priscilla Dehaney, and I'm here on behalf of Child Watch Legal and Hear the Children's Cry. We are an affiliate of Hear the Children's Cry. So, in a nutshell, considering the time, in the interest of time, we're going to try to see as much as possible how we can put this all in a nutshell. So, first thing we want to speak about is the fact that based on the memorandum of objects and reason. I see where many persons have mentioned this before, so we don't want to belabor it. But the memorandum of objects and reason at the end of the bill points out that the amendment is inspired by the unabated murder rate. The lawmakers therefore desire to lengthen the time spent in custody by a child who commits murder, presumably to send a tough message to other perpetrators and have a deterrent effect, to let the victims and the public at large feel like the seriousness of the crime is being taken into account and feel safer. It is noteworthy, therefore, that the first objects of the Child Care and Protection Act, as set out in the Section 3A, is to promote the best interest, safety, and well-being of children. In sentencing a child, therefore, the need to be tough on crime needs to be balanced against the best interest of the child. The best interest of the child should be sentence geared at rehabilitation, restoration, and integration. It would be a justice system that is concerned with tackling root causes of crime, preventing offending and re-offending. It is therefore against this background that we vehemently oppose this amendment to the Primary Act, and we seize this opportunity to address the issue at hand under Section 78 of the bill, particularly Section 78.3. So, on the grounds at which we are relying on today is based on international laws. The likelihood of rehabilitation is being disregarded, and judges' discretionary powers are being undermined if this bill was to pass. Based on the international laws that we have looked at, particularly Canada and the UK, we have decided and we are proposing a sliding scale. What is this sliding scale? Based on the UK policy paper, we are looking at where it speaks to youth custodial sentences, police crime sentencing and courts bill 2021 fact sheet, and which was updated in August 2022. It speaks to the fact that judges' hands are often tied in handing down sentences to young offenders that are too lenient and potentially put the public at risk. We want to see a more coherent approach with courts, even more tools to pass appropriate sentences, and a better opportunity to balance public protection and the culpability of the child in question. So, our approach and our proposal today is that for children 12 to 13 years, there is no possibility of life imprisonment, but also 8 to 12 years custodial sentence, depending on the facts of the case. Parole may be considered when they have served 2/3 of their sentence. As it relates to children to 14 years old, and 16 to 17, there will be a different application for the minimum term. The approach for 14 to 15 would be a minimum of 10 years, and the approach for 16 to 17 would be 15 years in custody. When we look at the concept of rehabilitation, which is a primary factor in this matter concerning juvenile sentencing, we looked at Australia, and particularly the rehabilitation is possibly one of the primary sentencing purpose taken into account with regard to young offenders. It is deemed that when sentencing young offenders between the ages 10 to 18, punitive sentences are less likely to prevent reoffending than sentences that have rehabilitation as their primary goal. It is well established that when the goal of sentencing is rehabilitation, when the offender is successfully rehabilitated, then the community is better protected. It is noteworthy that if this bill was to become law, then when a child at the age of 12 is sentenced to a minimum of 20 years before becoming eligible for parole or so, then that would be result in that child coming out at 32 years old before he's given an opportunity to experience freedom and a normal life. This, in our view, is cruel, excessive, and does not promote rehabilitation, which in essence should be a primary objective. We are therefore proposing that in the event of sentencing, we take notes from our international friends who have imposed sentences in tranches based on the age range and having primary goal of sentencing being that of rehabilitation. It is suggested that we invest more time and effort in programs and avenues where our at-risk youths may be positively engaged prior to joining criminal gangs and participating in criminal activities. If they have been solicited in criminal activities, we should endeavor to restore them, reintegrate them into the society with the skills and with a reasonable time for them to become gainfully employed or educated, reducing the likelihood of remaining complacent and being reintroduced to crime. Rehabilitation versus penal sentences. Research finds that juvenile incarceration increases crime likelihood gradually. What is our overarching goal or objective, as we have said before? Rehabilitation and reintegration. We should focus on identifying the areas of change needed to prevent prevent incarceration and crimes. In addition to Jamaica, many jurisdictions have removed or abolished or made the death penalty unconstitutional for children and young people. But why? This may be particularly because of the notion that children under 18 years are less developed have less developed psychosocial skills compared to adults. This must be compared to the impact of a life or excessive sentencing period. Studies show that young offenders released without rehabilitation experience result in worse mental health, depression, and suicidal thoughts. Many also return to criminal activities due to lack of education, skill sets, social relationships. When sentenced to rehabilitation programs and therapy, offenders can reintegrate into their communities, being employed, skilled, and gaining social and personal relationships. Rehabilitation allows offenders to realize their offense and learn to change their mindset to prevent future crime. Punishment involves incarceration. Putting offender behind bars usually result in one thinking about their offense. When we think about the sentencing principles, one must reflect on the balancing act. That is, to prevent offending by children and young people, which is also taking into account the public interest, but also we must balance it against the welfare of the children or the young person or so. Seriousness of offense should be the starting point. However, sentencing should be individualistic and focused on the child or young person as opposed to offense focus. Children are not fully developed and have not attained full majority. In international laws, it dictates that custodial sentence should always be a measure of last resort for children. Custodial sentences should be imposed when the offense is so serious that no other sanction is appropriate. So we are not against custodial sentence, just to insert, but it must be measured against the circumstances. We also look at judges' discretionary powers being undermined if this particular bill was to be passed. It is well established that with separation of powers, judges have an inherent jurisdiction to exercise discretion within the ambits of the law over matters that are brought before them. As a result, if the bill mandates a minimum term of 20 years for children, this undermines and limits the flexibility that is usually afforded to the judiciary. Judiciary, which is vested with the powers and the authority to make decisions based on merits of each case, will be tightly restricted to impose a sentence despite the facts of the case. This is unreasonable and certainly indicates a disregard for the rule of law, where Parliament is manipulating the hands of the court. It is clear that the judiciary, which interprets the law, would be confined to what is established in the bill, despite a child at age 13 who may be brought before the court as case A, who murdered one person as a result of his tainted environment, would prove this, versus child at age 17 in case B, who murdered several people without a cause. In essence, if case A and B are brought before the court, both in the circumstances may be given the same sentence at a minimum of 20 years. Therefore, to deprive the court of their inherent power to assess the matters brought before them and to make a determination of a child's age, reason for committing the crime, the number of times the child was found liable for similar or the same crime, among other things, should not be disregarded. The court should be given an opportunity to have a lesser sentence, that is for children at different age groups or ranges, and the factors that contribute to the result of the child being brought before the court. And in conclusion, we humbly request that you take this submission into great consideration as advocates and interested parties into the matter concerning the well-being of our children. We pray that your hearts will be pricked and your good conscience will prevail. In closing, the lyrics of the song, Greatest Love of All, by the late Whitney Houston, resonates with me. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us how we used to be. If we believe that our children are our future, despite their errors or mistakes, there should be room and time for rehabilitation for our children to become reinstated and reintegrated in our society so that they can become better fathers, better mothers, and citizens. We by no means condone wrong, but we are all also cognizant of the fact that many of our children are victims and products of their environment who are groomed into criminal activities. We therefore suggest that the government allow the court to exercise its judicial powers to determine matters on its own merit relating to each child and the sentence that should be applied. Children, despite conviction, should be treated with consideration to their rights, and therefore, even in serving their sentences, they ought not to be placed in an adult facility, but to be placed among their peers in a youth facility. That is the end of my submission.
Yeah,
thank
you very much. I want to thank all the presenters today. Unfortunately, we have to leave now. We were told we should be out here from 12:30. I beg for another half an hour. Because Parliament has to start, they have to prepare for Parliament. So I want to thank you, DPP, the advocate, the Children's Advocate, Children's Watch, and the Child Watch Legal. Thank you very much for your presentation. You can be assured that the points you made will be taken into consideration in spite of questioning and so on. We do appreciate, your position. The fact that some of us may seem to have a question in the opposite direction doesn't mean that we don't believe that what you have said is of good merit and good value. They will be taken into consideration when we consider the final position. So thanks, everyone. Thank you, members, for being here. Can I have a motion for adjournment? We're going to try to meet next week, okay? We'll let you know what time next week. We want to finish up during this term. Thank you very much, everyone.
say, you better hold out another day. Change one day, hey, but I'm with me, I'm gonna praise you anyway. Lord, I'm gonna praise you. Hey, He restoreth my soul. Watch me now. Hey, I'm Mr. Down in the valley, so lonely and cold. My body is shaking to my bones. My Savior said He'll dry the tears from my eyes. He tell me, say, all I need He will supply some my needs, yeah.
He's keeping. Now put your hand over your head and just say, cover me, cover me, cover me under your blood. Cover me, cover me, cover me. Oh, 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 oh. Oh, oh, Jesus. Here you now, blessings are on. I'm in look east, west, north and south, and it a come at me.
Blessing around me, dog.
A goodness and mercy overtake me now.
Blessing around me, dog.
Yes, me look east, west, north and south, and it a come at me.
Blessing around me, dog.
Oh, keep me true, Lord Jesus, keep me true. For there's a race that I must run, and a victory to be won. Oh, give me power every hour. Keep me true.
It was too much trials, yeah. I came out more than a conqueror. I am more than a conqueror. I am more than a conqueror. Jesus made me conqueror. I am more than a conqueror. Hey,
come look through in this whole some way astray, them astray. Salvation when that should play. I choose God's will, not the benefit. I choose to live right and I'm loving it. I choose to love my friends and my enemies.